Yes, Mr. Chairman, members of the committee here, I am to present House Bill 2072. I believe the clerk has a substitute prepared.
Council, please report the substitute.
Thank you, Mr. Chairman. I would just tried to post it on LAS. I was notified that it is down, so if someone can't see the online copy, I'll do the best I can. The substitute to the bill changes the Section C of 19.2.386.1 in the original bill. I'll give everyone a minute to get to that. So Section C had struck language that was in the existing code, and italics would be code that would be new language that would be adding to the code. The substitute keeps most, if not all, of the original language, takes most, if not all, of the new language that was originally introduced away, so the code would look essentially the same as it did. It includes a line, or I guess you would call it a clause, from lines 37 to 39, and the clause 2 on 41 is amended in part with an extra line added on line 44. Though that code section, that subsection, is the only amendment with the substitute.
Okay, is there a motion to adopt the substitute?
Second.
All right, all those in favor say aye. Any opposed? Hearing none, substitute is adopted. Delegate, if you wish to speak to it.
Yes, Mr. Chair. Speaking as a substitute, the bill was originally drafted, was attempted dealing with several issues in Virginia's civil asset forfeiture system, primarily those issues with assets forfeited by those not guilty of any crime and have made claim to those assets. After speaking with and being educated by the State Police Sheriff's Association in VACA, the attempt of this substitute was to address their concerns and narrow the scope of the legislation significantly, as mentioned by counsel. So first, when no finding of guilt in the underlying criminal case is made, it requires notice be given to the owner of the property or to the person whose custody of the property is found, informing them the process by which they have and can have the seized property returned. Our understanding of existing law is that the operation of this process is that a notice is sent to the individuals, but in its context, of a clear need to appear or make representations in the civil existing forfeiture proceeding. So our goal is to make clear that these individuals who are not found guilty of any crime or in relation to the seizure and that they are legally entitled to the return of their assets, provided they make a claim of ownership. The claim of ownership piece is really critical here, as I believe the State Police and Sheriff's Association sort of made clear that, given the example that to me by the State Police was that if an individual was arrested for possession of a backpack, let's say a backpack with drugs and cash inside, if that backpack did not in fact belong to that individual, that the individual was acquitted by trial and arguing that the backpack was not theirs, they did not belong to the bill, the original bill would have still allowed that person to get the backpack. We don't support that. So from the perspective of law enforcement, I believe that this is an improvement to the current process, as it will allow them to continue the forfeiture proceedings before the end of the 21-day period when not guilty defendants submit a written demand for return of seized property. It also has a consequence as well. In my understanding, not allowing the property to be forfeited under the timeline of an acquitted defense has made claim to ownership in a legal filing or proceeding. For example, under the law, if the cash is seized, the defendant testifies that the cash was his or hers and was for paying rent, and the defendant is found not guilty, that cash will be forfeited to the defendant and does not make a written demand. It's returned if it does not make a written demand for its return in 21 days. So if enacted, to sort of sum it up here, if enacted, the substitute would allow that cash to not be forfeited when the Commonwealth was required to inform the individual by the process by which they would be returned. So in summary, I ask you to, and the substitute would allow the Commonwealth to continue with the forfeiture proceedings because the defendant has made a claim of ownership. So I ask you guys to let's take a little bit of responsibility in the asset forfeiture process. If you're found not guilty, that the Commonwealth should take every effort to return it to you. However, if you successfully disclaim assets as it means to and escape some criminal responsibility, those assets should immediately be subject to the forfeit, even at forfeit at the conclusion of your trial.
Okay, thank you. Any Questions from members of the committee?
Mr. Chair.
Delegate Williams.
Ms. Glass, Delegate Glass, I'm sorry. When these actions begin, are they served civil process?
So initially when they start their criminal process.
All right, follow-up question, Mr. Chair. So wouldn't it be their responsibility to keep track of their calendar days and their civil matters if you're asking us to take responsibility for it?
I believe whether it's a civil or criminal process, it is the person's responsibility to, Mr. Chair, to keep track of dates.
Thank you. No further questions.
All right, thank you. Any other questions? I would have a question for counsel. It seems to me there was a recent overhaul of the procedure on asset forfeiture that was passed a few years ago. Am I correct in that?
Mr. Chair, yes, you're correct. The overhaul was that now requires criminal conviction in order of a violation that allows for forfeiture in order for the forfeiture to be granted to the Commonwealth.
And as part of that substantive change, wasn't there also changes made in the notice requirements?
In the initial notice requirements, the process by which they still do the forfeitures is relatively the same, in that you're served with a notice of forfeiture. What changed was, as soon as you're served with that notice, your case is automatically stayed until your criminal case is resolved, and then after your criminal case is resolved, the case is placed back on the docket for forfeiture. And if you're found not guilty of the crime, then the case is automatically dismissed at that point.
Okay. All right. And so, Delegate, I would ask you, in light of the, did you take into consideration the recent changes before you proposed the bill?
I looked at the 2015 or so study that you all did, but what we were trying to do is make sure that there was a clear, within that notice, that it was clear that they have the right to get their assets back, not just a notice that they need to appear or that they need to represent themselves in a civil case, but actually the process by which saying that they have an actual right to those to their assets.
Okay. All right, thank you. Anyone in the audience wish to speak in favor of the bill? Or anyone who wishes to speak in opposition? No one online? Okay. Any last words before the committee takes up the... Oh, I'm sorry. There is opposition.
I apologize, Mr. Chairman. Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County, here speaking on behalf of the Virginia Association of Commonwealth Attorneys. I appreciate Delegate Glass made time to speak with us and listen to our concerns, and a number of the concerns have been addressed. And I've been trying to go through the substitute here in somewhat of a rush. Again, a lot of our concerns have been addressed. I think maybe I'm not entirely sure how the substitute would really work. My understanding is that the concern was that if someone was found not guilty and they didn't show up for 21 days to pick up their property, that was unfair to that individual. And so it addresses it by both making sure the Commonwealth sends them notice, educating them yet again, we have your property. If you don't come within 21 days, then we're going to keep it. But then it also takes out the 21 days from when there can be an exception to that rule. So in essence, the way I'm reading little I, such forfeiture is ordered by the court by plea agreement, or the person whose custody of the property was found has not made any claim of ownership in any legal filing or proceeding, there's no timeline there. So upon the not guilty finding, if they hadn't before trial made that claim of right, then I think she's changing the law to really remove that 21 day, because as soon as this finding has been made of not guilty, if there has not been a claim of right, then it becomes automatically forfeited. I don't believe that was the intent, but it's just something that I caught reading through it. This is, again, in that area, it does require the Commonwealth to take an extra step. We've notified them that we've seized the property. We've notified them of the procedures. This would then notify them again of what those procedures are after a not guilty finding. While that That does provide some extra work for us, but that's a policy decision for this committee to address. The idea that we shall not do asset forfeiture on anything less than 200 or 2,000, again, somewhat policy, but I am somewhat opposed to, if you know that this individual was dealing drugs, but he only profited $200, well, he gets to keep that. So basically, you get to keep the first $200 of your profits, but anything after that, we get to go after. I'm not, again, that's more of a policy decision, but again, that's how I read the change.
Okay, thank you.
Elizabeth Hobbs from the Virginia Sheriff's Association. I also really appreciate Delegate Glass approaching and hoping to come up with something that we can all live with. It's much appreciated. We are nonetheless still in opposition, specifically the limitation on the cash value and the monetary value of the vehicle. At first glance, seems to be a very small category of people who maybe do not have a lot. But really, asset forfeiture often arises in a singular circumstance with money in a pocket at the time that someone may be arrested. And so although you may have $150 in your pocket then, every subsequent controlled buy of narcotics may reveal an additional 150. So over the course of 6 months of controlled buys of narcotics, you may have numerous occasions in which you have separate $150 allotments. Adding those all up together may be thousands. But under this bill, all of those will be precluded from asset forfeiture and thus encouraging or not discouraging, if you will, the proceeds from the drug trade. We oppose.
All right, thank you. Okay. Any last words, Delegate?
Oh, my apologies, if I may. That section C, I think we want it struck from. So that's my apologies for not looking at the substitute completely. That's why I didn't speak to the 200, 2,000 piece of the bill.
Okay.
Mr. Chairman,
Delegate Watts?
it's a motion in order to strike lines 73 through 76 of the substitute.
Okay. All right, there's a motion and a second to amend, and if the delegate could restate that for council, please.
Pardon?
Could you restate
I'm
that for council?
striking lines 73 through 76 of the substitute.
Okay, and that's what the delegate wants. Okay.
Yes, Mr. Chair.
All right, all those in favor say aye.
Aye.
Any opposed? All right, hearing none, the substitute is amended. Okay, and does that conclude your presentation?
No final words. What was
Okay.
said is accurate.
All right. So the committee has heard the arguments for and against. It's before the committee.
Mr. Chairman, I move that we report as amended, substitute as amended.
Mr.
All
Chair,
right.
substitute motion.
Okay. Substitute motion, please state it.
I move to PBI.
All right,
The bill.
The amended substitute.
Yeah, the amended substitute. Thank you.
Is there a second? Second. All right. There's 2 minutes for debate on that motion.
For the reasons argued before this, I would resubmit that to the chair and stop talking. Thank you.
Okay. And any argument from the
I yield
opposition?
my time to the patron.
I just agree with what the Commonwealth's attorney said. What we were trying to do is, have them. It would have made a little bit more work, but give them another opportunity to let a person in this case the chance to know that they had a right to get their things back. So oftentimes when we look at folks dealing with criminal cases where they're seized assets, that sort of can get lost in the shuffle. So I think it would be a service to us and to citizens of the Commonwealth that go through this process to serve that other notice after they completed a criminal process. So I'm asking you all to support the bill.
Okay, thank you. All right, the motion to pass by indefinitely has been made, seconded. We've had debate on both sides. Please record your vote on the motion. Yours did not record. All right, please close the roll. All right, the motion carries by a vote of 5-2.
Thank you, Mr. Chairman.
Thank you for your presentations.